Hello, you're very welcome to this audio presentation. My name is Seamus McGranahan and I'm a director at O'Reilly Stewart Solicitors in Belfast. This audio presentation relates to an introduction to the General Data Protection Regulations, or GDPR as they're commonly known. So what is GDPR? As I've said previously, GDPR stands for the General Data Protection Regulations, and the key there is in the name in relation to data protection. GDPR came into force on the 25th of May 2018, and the Information Commissioner's Office, or the ICO, as you'll hear me referring to throughout this presentation, advised that there was an expectation that everyone was to be compliant in advance of commencement of GDPR on the 25th of May 2018. So there's been a lot of events that have taken place in the run-up to 25th of May. There has been lectures, there have been emails, various pieces of advice provided in respect of GDPR, which has led to some confusion and some difficulties in understanding the impact and the effects of GDPR. Essentially what GDPR does is it looks at strengthening the rights of individuals in respect of their personal data and provides more control for those individuals. So if you take yourself personally and you think about all of your personal data that is held outside of your control, essentially, if you think about the data that your employer holds, or your bank, your credit card companies, or indeed any clubs and societies that you might be a part of, they all hold data in relation to ourselves. Now you will be aware that there has been the Data Protection Act in place since 1998, and we're all familiar with what our rights are under data protection. And I think it's really important to make the case and to be clear that although there are increased obligations for businesses in handling personal data under GDPR, the Information Commissioner's Office have been clear that GDPR is an evolution rather than a revolution. So what we're doing is we're building on the existing legislation under the Data Protection Act, and we're adding various additions to that through GDPR. GDPR affects businesses established in the European Union and those outside the European Union, but that offer goods and services to or monitor individuals within the European Union. Now we know that we're shortly to leave the European Union and the UK, but the UK government has been clear and has said that it will not in any way relinquish rights under GDPR. GDPR came into effect on the 25th of May 2018, and certainly it is here to stay. As part of this presentation, we must look at the risks of non-compliance of GDPR. Now, a lot of this has come from the scaremongering out there, specifically in relation to all of the risks that we've been told about through these various reports, through the media and the emails that we've received, advising that GDPR comes with additional liabilities, and that is true. There's three main points I want to make in respect to the risks. And the first one is that the upper limit on fines under GDPR will increase from £500,000 under the Data Protection Act to the greater of €20 million, or alternatively 4% of annual turnover. So that is substantial. And I'm going to talk in the next slide about the existing case law, but certainly what we can say is that risks of non-compliance under GDPR will certainly be hit with heavier penalties. In any event, 4% of anyone's annual turnover is a substantial amount of money. In addition to that, there is going to be data processor liability. Under the old Data Protection Act in 1998, it was the data controller alone that was responsible. Now under GDPR, both the data controller and the data processor are going to be liable. So not just the company that you work for, but for the individuals that are processing the data itself. And the last one there is a really important one, that individuals can sue for compensation to recover both material damage and non-material damage. For example, distress or issues that have arisen as a result of a leak of your personal data. There are a number of cases under the existing 1998 Data Protection Act where individuals have brought claims against employers or companies where there has been a leak in their data. And I'm going to get to the case law shortly. But what I will say about it at this stage is that under GDPR, the the realms are wider and open up in relation to the ability for an individual to sue for compensation. Turning to some of the case law under the Data Protection Act 1998, as I previously mentioned, under the prior Act, the 1998 Data Protection Act, the Information Commissioner's Office had a power to fine individuals for breaches under DPA, and that was capped at a sum of £500,000. Now, what I will make at the start of this slide, the point that I will make will be that certainly the Information Commissioner's Office ability to increase fines up to the £500,000 has always been there. But what we've noticed and what we've come across is that the Information Commissioner's Office sought to increase fines on a gradual basis. So if we look back at some of the earlier breaches after the Act, the fines are lower than what they have been coming right up to recently there through 2010 and onwards. Just to talk briefly about some of these cases. The first case here that we have is Talk case. Now this was essentially a cyber attack that took place in 2015 in relation to data that Talk held. There was a breach of some 156,000 customers in relation to their data itself, and a number of the customers reported and made complaints to the Information Commissioner's Office. Now, in September 2016, the Information Commissioner's Office issued its highest fine ever to Talk, and that was in the sum of £400,000. This was a significant case, and I think that it does bring us closer to where the Information Commissioner's Office will move under GDPR. They will seek to increase the fines even more. And remembering that they have that ability to go right up to €20 million or 4% of turnover. This next case is the NHS Trust. It's the Brighton and Sussex University Hospital case. And what happened in this case is that whenever the Trust were upgrading their computer software and their hardware, they threw a number of old computer systems, including the boxes that we have under our computers, into some skips outside of the building. What happened was that an individual came along and saw these computers in the skip and essentially helped themselves, took a number of the computers home. One of the computers appeared on eBay and someone bought the computer, and whenever they put the computer on at home after they bought it, they were able to bring up all of the documentation that was stored on the computer. So you think of all those really important, delicate and sensitive computer records that hospitals hold relating to people's personal data, their medical information. All of this was available on the computer that had been taken, and the fact that it was left outside in an open skip with no security on it by the Trust, the ICO really went heavy in terms of this, and there was ultimately a fine of £325,000. And the ICO were very critical of the Trust in the sense that they had just simply discarded the computers. They hadn't sought to clean or wipe them, first of all, and they'd left them in an open space where any member of the public could have came along and taken any of the computers. In March 2017, there was another case where ICO fined a barrister for £1,000. Now, this is an interesting case in the sense that the barrister used a home computer for personal work also, and the barrister's husband took the home computer and downloaded some new software. Now, there was actually a virus contained within the software whereby it lifted a lot of the information contained on the computer and published it on a website. And what this resulted in is that there was a number of sensitive cases that the barrister had been dealing on, that this barrister had placed on their home computer. And ultimately, this sensitive information belonging to clients ended up in a public forum. The ICO sued the barrister £1,000. It does appear a slightly harsh case in the sense that the barrister didn't actually do anything wrong in terms of a breach. It wasn't so much of an open breach, it was the fact that there was a virus in the downloading of some new software that took the information and placed it somewhere else. I think that's probably reflective of the fact that there was a £1,000 fine, but it is an example of cases that can happen to any of us and how careful we need to be when dealing with data, specifically in a digital format. This last case of Stoke-on-Trent City Council goes back to October 2012, and you'll see that the fine here is quite high. It's £120,000. And the background to this is that there was a solicitor, again this is another legal case, whereby the solicitor was sending information out via email to a number of parties. Now, on 11 of these emails that had been sent, she had sent information to the wrong third party. So if you think of those situations, and it has happened to a lot of people, and certainly a lot of people that I'm aware of, where you type in a name on your email and it brings up a list of the last number of people that you've emailed with the same letters of the alphabet in the name. This solicitor had done this 11 times, and essentially the email had gone to the wrong party, and eventually the matter was reported to the Information Commissioner's Office. I suppose that the issues for the Information Commissioner were that there had been really two significant breaches in terms of the fact that, number one, it was a solicitor who should have been better informed and aware, and second of all, it had happened 11 times, and there is that aspect of learn from your mistakes. So the City Council on this one were fined £120,000. Moving on to our next slide is, well, we've talked a lot about personal data here, but what actually is personal data? And what I've said is that GDPR widens the scope of personal data. So the definition in the 1998 Act was a lot narrower, and it has been widened under GDPR. And essentially personal data means data which relates to a living individual who can be identified from the data or from those data and other information which is in the possession of or is likely to come into the possession of the data controller. So the key points are that you have to be a living individual, and again your identity has to be capable of being identified from the data itself. So if it's a lot of redacted data that doesn't really show anything bar maybe dates of birth, that mightn't be able to identify you personally. But then again, if you are looking at, say, recruitment records where there's 5 individuals interviewed and the 5 individuals were in a room at the same time, you could certainly see a situation arising whereby, as a guesstimate, you could identify the person's data on the basis of their date of birth. What's really important under the GDPR regulations are that personal data also includes any expression of opinion about the individual or any indication of the intentions of the data controller or any other person in respect of the individual. So if you think about things about appraisal records or maybe personal notes that a line manager will keep in a member of staff, if they include an expression of opinion, then the third party, the individual, is entitled to access to that information that's held about them. Let's look at some of the major changes that have been brought in under the GDPR. The first one here is that individuals have the right to require erasure. No one has the right to be forgotten, and essentially an individual can write to any organisation that holds data in relation to it and ask them to delete that data or remove it. This isn't always going to be possible. For instance, you can't write to your employer and request that they delete all information in relation to you. Your employer requires that information, but where the organisation does not need to hold the information any longer and they receive an application from an individual that they want to be forgotten, they should proceed to do that, and they should have a mechanism in place in order to do that, whether it's the deletion of digital records or paper records. The next one is that the individual has a right for inaccuracies to be corrected. And really that's straightforward enough. If the individual is aware that the information that a organisation holds about it is correct in any way, they can contact the organisation and ask them to amend it to make sure that it is correct. There's an obligation on the organisation to make sure that those inaccuracies are corrected. The next one there relates to the subject access request. Now, you may be familiar with SAR requests as they're known, but there has been a change. There's been a reduction in the time that organisations can deal with those. They're now reduced to 1 week. It's 20 working days, so it's 4 weeks in order to comply with the subject access request. And you're no longer able to charge anything for a SAR request. It used to be that you could ask a individual for monies in respect of if there was a lot of documentation to copy or something along those lines. But now that is all gone. You've 4 weeks, and that's it, 20 working days. There's a right also to prevent direct marketing. And again, this is an aspect whereby we all receive emails from companies and organisations that we're not aware of, marketing their information to us. Now, this is one that's caused a bit of controversy. It's not a situation that organisations that you have either worked with before, or maybe, for instance, a hotel that you've stayed in, of them sending you marketing information. If they do send you marketing information and you don't want it, you're entitled to write back and say, it's my right of erasure, please remove me, or please don't send me this information. But what shouldn't happen is that you shouldn't be essentially receiving things cold turkey from companies and organisations that you haven't interacted with before. There's also a right to prevent automated decision making and profiling. Now, as you know, this will happen quite a bit if you go on to the likes of any of the shopping sites like Amazon and you buy something. They profile your account. They look to offer you similar items or items that you might be interested in. There's also a situation where some organisations run automated decision making, whereby there's random selections done and things like that. There's a right for you to say as an individual, I don't want that to happen any longer, and the right to request that there's a removal of your information in that respect. Again, there's this new right as well in relation to data portability. So if a organisation holds documentation in respect of you, and you request that they transfer that documentation to another organisation, then they're obliged to do so. So it would be the likes of if you're moving bank accounts, or you're transferring some sort of account or something that is holding your information, and you're saying to the person holding that information, just simply transfer what you have on to the next person. Again, if you were an organisation and you got an instruction in respect to that, you'd want to make sure that it was in writing and that you've recorded it. The last one there on this slide is privacy by design is a requirement. And this is really talking about the implementation of technical and organisational measures and safeguards. What we're looking at here is if we are introducing new software systems in our places of work, that we're looking at that from the basis of protecting privacy. So we should, in any new system that we're integrating into our organisations, whether that is digitally or otherwise, it should always be on the basis that you're considering the privacy element and that you're essentially working that into the process that you have. So it should always be on the mind that as a result of any new system that you're putting in, that you also have to consider the privacy aspect. This next slide is dealing with the major change in and around consent. Now, what you will have come across before is that a lot of companies and organisations will have said in the past, well, look, if you've worked with us before or you've bought something with us, it's an implied consent that you want to hear further from us, or that you're happy for us to contact you. Under the GDPR, the situation is that consent, where it's required, must be freely given, specific, it must be informed, it has to be unambiguous, and you have to require separate consent for different processing activities. So it's not a situation now where you can say tick the box for consent and that will cover all aspects. What you're looking at now is that the consent has to be very clearly given. It should be in writing. It should be about a specific piece of processing that's taken place. And if there's processing of the data taking place outside of that, you need to obtain another form of consent in relation to it. Our next point is that there must be a positive opt-in. Consent cannot be inferred from silence. And if that does happen and you do get a positive opt-in, you should really look to retain a record of how, why, and when it comes to consent. It's not sufficient enough any longer to say if we don't hear from you, there's an implied consent. There actually has to be a positive opt-in where either someone is signing off or ticking the box or giving some clear indication of their consent. And lastly, in relation to consent, there must be a simple way for individuals to withdraw their consent. Now, this seems fairly self-explanatory, but it's situations whereby if you don't want to an organisation to any longer process your data, that there's a simple enough process for you to contact them and say stop. And whether that's by notifying of a specific individual or a specific part of the website where you can go in and deregister essentially, but the regulations are clear that there must be a simple way for it to happen. Now, while we're talking about consent, I really want to cover off on the issues that it's just not all about consent, as I've said here. And one of the key issues, and certainly a lot of the scaremongering that has happened in and around GDPR, has been that you need consent for everything. And the Information Commissioner's Office has been very clear that it's just not all about consent. And you need to ask the question, do you also need to process data due to any of the following? And what I would say to you is that there's 5 bullet points here. And if you are required to process data as a result of any of these, you don't need to obtain consent from the individual to do so. So the first one there is a contractual necessity. So if you enter into a contract with someone, so if someone applies through your organisation for products or for work that they require done or completed, if as a result of the contract you need to process data, then you need to do that. You don't need to go back to obtain consent. The next one there is compliance in relation to legal obligations. And again, if as an organisation you have to process data as a result of a legal obligation, you don't need to go to the individual to get consent. You can proceed to do that. The next one there is due to the vital interests of the data subject. So for me, a good example of this is that if you have to process an employee's data in order to facilitate their payment of their salary, it's obviously going to be in their vital interests that they're paid, and there wouldn't be any difficulty with that. Also, if we want to look at vital interests, we can also consider things like our next of kin and the processing of data or releasing of data of the individual to a third party as a result of contacting their next of kin, and you would be given their data across in that, but it might be for a vital interest. The fourth one there is in the public interest, and again, if you're going to whistleblow or you're going to make declarations or complaints or reports in the public interest, you don't need to obtain consent in relation to releasing that third party's individual data. And the last one is an illegitimate interest there. If there's a legitimate reason for you processing the data, you don't need to get consent for it. Also, within the major changes under GDPR, I want to draw your attention to the following 4 points. The first one is a privacy impact assessment, and these are mandatory when dealing with new technologies or where data processing is likely to put at risk the rights and freedoms of individuals. So they're called a PIA, and essentially what it is that you would do an assessment within your organisation in respect of the impact that you may have on an individual's privacy as a result of processing their data. Now, we do have to look back and consider the various aspects of consent, and again, if consent isn't required because of some of those prior points that we talked about, then that's fine, but you still need to have a PIA done. The next one is about appointing a data protection officer. Now, this isn't an obligation on private employers or private organisations. It certainly isn't an obligation on public organisations. But essentially what you're doing is looking to appoint someone as a data protection officer within your organisation. And that's somebody that's going to be responsible for data protection within the office. And I certainly think it is something that is helpful. If Information Commissioner's Office attend with a representative, it would be in the benefit of the organisation to be able to say we've appointed a data protection officer and this is the person that you need to speak to in relation to investigation or breaches or whatever it is that they're attending for. Really important to point out that there is a requirement to notify the Information Commissioner's Office, and potentially any affected individuals within 72 hours of any breach taking place. So if you are aware of a breach, you're obliged to report that breach to the Information Commissioner's Office within 72 hours, and then also notify any individuals that are affected also. Failure to notify ICO where the individuals will only make the penalty harsher when ICO come to look at it. If you report within a neat time frame, it's certainly within the obligations of 72 hours, there'll be an understanding from Information Commissioner's Office that you're not trying to hide anything and that you're taking the appropriate and prudent steps. The last one for the major changes is really about increased accountability, and you have to be able to demonstrate compliance to the Information Commissioner's Office. So if you get an inspection and someone comes out, a representative comes out to your office, what you want to be able to show them is that you have carried out your audits, your privacy impact assessments, and that you've got policies and procedures in place in order to deal with data protection. So you want to have a policy and procedure in relation to general overall data protection issues, and under GDPR, your various requirements there. So if you're a public organisation, for instance, that you do have a data protection officer appointed, but you also want to have policies and procedures in relation to how you as an organisation process your data, what's acceptable and what's not acceptable, and even for things as a SAR request in respect of the subject access request, how that will be dealt with within your office. So it's important that your organisation is accountable and that you're able to show your accountability by the steps that you've taken. We're now going to look at how do we prepare, and at this stage your preparations may be well underway or you may just be starting out. It's important to remind you that on the Information Commissioner's website there are various documentation, pieces of advice, draft policies and procedures available for you to get into the preparation mode. There are tasks that you can complete and work through on the website that will help you prepare. One of the first things under the GDPR regulations is that you must conduct an audit. And essentially what you're looking at here is putting together a record of data processing activities by creating a data map or data flow analysis. Now this does sound complex, but really what you want to look at is the flow of information that is coming into your office and going out of your office. So for instance, you may want to look at how does the office receive information. Is it through your post, your DX, your internal external emails that are coming in? Is it in relation to application forms for job roles? Is it about the information that you retain in respect of your employees, your customers, your suppliers, your clients? So you want to really track out and flow the data processes that are running through your office. And essentially I think it's a good way to look at it, how it's coming in the front door, how it's processed internally once it's in your front door, where it's placed, and then how it leaves your office as well. So it's looking at both the internal and the external ways of processing data. And you have to look at how you've captured the data, why you're capturing it. It's important to look at whether or not all the information that you're capturing is entirely necessary, and do you need to have that information, and do you need to retain it, which brings you on to the purpose of having the information. If you're holding lots of information that you don't necessarily need, the safest thing to do is to change your processes so that you don't get that information any longer, or alternatively, if you have it, think about disposing of it and disposing of it safely. You also want to look at your retention policy. How long are you keeping information for, and how long is that data being kept after you've processed it? There's lots of regulations out there in terms of how long you have to keep files and information, specifically in around recruitment. And your guiding principle there is 6 months after the completion of a recruitment process, you should be disposing of all of the relevant application forms and associated documentation. If you are retaining that and there is a data breach, for instance, if someone breaks into your office and takes documentation, or that as has happened in the past where there has been a clear out of the office and old filing cabinets have been left unsecurely, where information can be accessed by the public. You're putting yourself at risk really by holding documentation that you don't need to look at or that you don't need to retain. You need to consider your security in relation to that documentation. If it's stored digitally, is it password protected? Is there sufficient security and protocols in place in respect of maintaining that security? And the last one there is really looking at how you're sharing that documentation, who you're sharing it with. Do you have consent to share the documentation? So it's those sort of factors that you're looking into. The second thing in terms of how to prepare once you've done your audit is to review your IT systems and your procedures to ensure that the requirements under GDPR for both privacy by design and by default are met together with the data minimization requirements. Here you're really looking at the digital information that you're retaining and how your IT system may work. If you're working off a case management system, for instance, is there procedures in place within the IT system that will automatically red flag up dates, passwords, information that is out of time and ready to be disposed? Is it simple to erase information as required under data protection? So you really need to look at not just the paper trail coming in and out of the office, but also on the digital side as well. And the last one is to complete your privacy impact assessment. Then, where that is necessary, you do need to complete it. It's not always necessary, but certainly whenever you do, and certainly whenever you're doing any of these tasks, it's important that they're documented so that if you have an audit from the Information Commissioner's Office or a visit from them, that you can produce this documentation to them. We'll continue on here with our preparations. And our fourth one is to review your consent procedures, reminding you that consent isn't always necessary, but where it is necessary, you should have your procedures in place for consent and make sure that that is documented. We talked in an earlier slide there about consent, when it's necessary, when it's not, and what you need to retain in respect of consent. It's also important to remember that you have to have a system for withdrawal of consent. So whether that is a box on your website or something that a customer or supplier can approach and say, I want you to no longer process my data, there has to be the availability of that. Alternatively, that may just be something on the website or on your documentation that says that if you wish to withdraw consent, please contact our data protection officer, for instance. There has to be some mechanism there whereby you can, as an organisation, be alerted by someone that they have no longer provide their consent. The fifth one is something that we've talked about previously there. It's about the development of policies and procedures in respect of your organisation in terms of how to handle data protection and the privacy rights, and also training in that aspect. When we talk about it, number 5 here, the privacy rights requests, those are things like the SAR applications, the applications that will be received and how those are treated, and really you want to have a written down policy and procedure. It's best that if there is one person within a department or within the organisation that is tasked to deal with SAR applications, because these subject access requests are tight now, as I said, they're 20 days in order to process them, and where you don't process in time, you can expect that the person will be annoyed and that they'll make a potential complaint to the Information Commissioner's Office. The sixth one there is develop or amend existing incident response plans to detect and report breaches effectively. This is really important in terms of the Information Commissioner's Office audit. They will want to make sure that there's a process in place that where there are breaches, that there's a system for reporting and dealing with those breaches. Just by way of example, this week I had someone that had contacted me in relation to information was being decanted by this organisation to over 1,000 people. It was all done via consent and everything was in order, but there was a printing problem, and one of the pieces of information, one of the particular pages, got caught in the printer. It was removed from the printer but didn't reprint, and in line with all the information going out, a lot of the documentation went to the next person on the list rather than the actual person, resulting in a substantial breach of around 250 people getting other people's information. This happened over a weekend and it wasn't alerted until a Saturday, and I got a call on the Monday wanting to know what to do. And it was a very simple process of the first thing that needed to be done was to check, exactly the information that had been sent out, the mistake that had been made, and documenting the error that had been made. And the second thing to do was to look at how to rectify, or if it was possible to rectify it. The third and fourth steps were really to look at reporting, advising those individuals that had got the wrong information and getting the right information to them and giving them an explanation of what had happened. And then the last thing was really to look at how do we prevent this from happening again? What is the lesson that we have learnt? And it's really important whenever you're going through a process of a breach that you are taking away what is the lesson here and what can we do to prevent this happening in the future. That's a key thing for the Information Commissioner's Office. They'll want to know that you have taken on board, you've examined, you know why the breach happened, how it happened, what steps can be taken to prevent it from happening in the future, and making sure that that's documented to ensure that it doesn't happen again. And it's a bit of an act of contrition in terms of that with the Information Commissioner's Office, but generally my experience with them tends to be that if it is a hands up exercise where you're saying, look, we've made a mistake, but here's what we've done in order to attempt to rectify it, that they won't seek to slap penalties on, they will give you advice and guidance. The last one there is to make sure that you carry out your regular security audits, and that is important to make sure that you're keeping on top. You may be an organisation that has never had a breach, but don't get complacent. Ensure that you're carrying out regular audits in terms of your documentation and your data processing to ensure that there won't be audits in the future. Our next slide here is dealing with privacy notices. Now, under the GDPR and under ICO guidance, all organisations have to have a privacy notice. And it's quite simple in the sense that you can go onto the Information Commissioner's Office website and they will give you clear assistance in terms of a privacy notice. In fact, they've got a precedent on there that will suit a particular type of organisation that everyone can adopt. Now, you can adopt and you can amend the privacy notice, but there are certain guidance in and around the privacy notice that you have to adhere to. So a lot of organisations will have their privacy notice it'll be documented on their website, or alternatively, it'll be located on a document within the office that they'll send out or that they'll provide to their customers, suppliers, their clients. The privacy notice must be clear and it must be in plain language. It has to be understandable. It also must be transparent and it must be easily accessible. So a lot of the ways for organisation to make sure that it is accessible is to have it on the website. And you'll often see drop downs on websites in relation to data or legal obligations, and you'll come across the privacy notice in there. The privacy notice must contain 4 main points. It must provide the legal basis for processing the data. So if you're processing data within your organisation on behalf of your clients, your suppliers, your customers, your employees, you have to be saying what the legal basis is for processing the data, and that will often come along with what the business of the organisation is. The next is that you have to detail out what your data retention periods are. You have to advise people for how long you're going to hold their data. And again, the best way to deal with that is hold the data why it's necessary and why you need it. Thereafter, safely dispose of it. The next one is you have to give the individual a right to complain. If they're unhappy about some process in respect to how their data is being dealt with or handled by an organisation, there has to be a right for them to complain about that. So often what that will take the form of is a complaint to the managing director, or as we have now, the data protection officer. But it's a right for an individual to make a complaint about how you're processing their data. And the last thing is that you have to put in your privacy statement is whether data will be subject to automated decision making. That will affect some organisations more than it will others. Some organisations, if they are applying criteria or selection, they will do it randomly through an automated system on the computer. If you're going to do that, you need to let your clients, your suppliers, whoever it is, know that that's what's going to happen. But as I say, there is a precedent up there on the Information Commissioner's Office website. It's clearly adaptable, and also it doesn't help that if you look at your competitors within your business, and have a look at their privacy notices and see if there's assistance that being taken from them. I'm certainly not advising you to copyright or anything like that or breach any of those laws, but it can be helpful to compare and contrast. This is one of our last slides, and we're still in the theme of preparing for GDPR, or if you're in the process of getting your organisation compliant with the regulations. The last one is really talking about appointing a data protection officer. Now, as I said at the start of this presentation, it's not always necessary to appoint a data protection officer. If you're in the public sector, it is a requirement. If you're in the private sector, it isn't, but it can be a good idea. Just a couple of things in and around the data protection officer. I think it's a good idea to always have someone centrally in your office that's responsible for data. So if there are breaches, that there's someone there, a dedicated person that can deal with those breaches, someone that is suitably trained and is able to react in terms of these breaches that happen. It's also really important to identify somebody within your organisation where your employees have queries and questions. Maybe something arises that they're not sure what to do. It's important that there's somebody within the organisation, and that's an identifiable person that can assist and provide them with advices or guidance in relation to their queries. So I do think that it's helpful to have a data protection officer. I'm not saying that it's always strictly necessary. It'll depend on the size of your organisation and the resources available within your organisation. But where you are processing significant amounts of data, I think it's a prudent step. Your data protection officer can be full or part-time. They don't necessarily have to be a full-time member of staff. And often you'll be able to identify somebody within your office that's kind of already looking after the data protection aspect. Often that can be the office manager or someone within that position, or maybe it might sit with finance within your organisation. But it's important just to identify where it's best placed. It can be somebody internal, or you can also contract out. As a result of GDPR, there are plenty of consultants out there that are making a living by assisting and providing guidance and advice to organisations who are willing to act as the nominated data protection officer. That can be an expensive process, and if you are going to consider that, it's worthwhile speaking maybe to a couple of the consultants and getting quotes and seeing what it is that they will do and what they'll not do, and what exactly they'll be responsible for. Really important that your data protection officer is independent, that they're accessible and they have expert knowledge and report to senior management. What you want is a strong individual. My experience tends to be from my clients that a lot of data protection issues arise. The company want to kind of cover it up. They don't want to get involved. They're worried about reputational damage. And a lot of these things are not taken seriously enough and are put under the carpet. There can be a tendency to bury the head. What you want is a strong individual, someone that will stand up to the senior management team, somebody that won't be afraid to voice their opinion and be clear about what their advices are when it comes to data protection, and whether that's a breach or whether it's guidance that is being provided, what can and cannot be done. But you don't want, I suppose, a meek individual or a quiet mouse who isn't going to be clear about what's right or wrong. You want a strong individual that is going to give the advice and essentially keep the organisation safe. The last point there is be aware whenever you're selecting your data protection officer of any potential conflicts of interest. Best that it's not a member of your IT or security personnel. They're too close to it in terms of data protection. It should be somebody that, as I say, is going to be a strong individual, but that has no conflict in terms of data coming in or coming out of the office. Just while we're on the aspect of the office itself, before I conclude this presentation, I think it's important maybe just to give a few helpful tips in respect of what you can do inside your office when it comes to data protection and what the expectations are under GDPR. The first one is really don't give out confidential information except to the data subject, i.e. your client or your customer or your supplier. Information should not be given to an unauthorized third party unless the data subject has given their explicit consent. So, if somebody's mother, brother, partner rings up seeking information about the individual, they may tell you on the phone that they have consent. That's not good enough under GDPR. You should be looking to speak to the individual themselves and make sure that they've provided you with consent, or that they've given written consent in an email or in a letter. It's important then that you always identify the data subject and the legitimacy of the request. A lot of organisations now have telephone verification procedures. And you're thinking there really about security questions that you can ask the individual to ensure that it is, in fact, the person that you're talking to, that's the data subject themselves. Other important point is only transmit personal information via a secure network. We're all using email for the vast majority of our communications now. Just make sure that your email is protected and that it's not going to be subject to interference by an unauthorized third party. Real simple tip for inside the office is to ensure that when any data held, that it's kept secure when not being used, i.e. lock the documentation in a filing cabinet, or if it's computerized, password protect and encrypt your documents so that there can't be any sort of unfair or illegal access to that documentation. Shredding is another one that's really important. We should all have shredding bins when disposing of personal information. Do not put them in your waste paper bin. There's a number of ICO cases where documentation has been placed in waste paper bins, put in black bags and left out the front of the office or the organisation premises for collection. And that documentation is sitting out there exposed, and it's a breach waiting to happen. Simple thing as well, whenever you're inside the office, always lock your computer when you're not at your desk. And if you receive a request for personal information about another employee, send it on to the office manager or your data protection officer or somebody with authority in the office. And again, your policies and procedures should be detailing that out so that all staff and employees are clear about what the processes are. Password protecting is always really important. All phones, tablets, laptops, USB sticks, they should all be password protected so that you can't have the potential of being hacked or those devices being subject to a data processing activity whereby it's going to result in a breach. Good one is always to make sure that you update your software. Each software update that takes place will provide further security settings and will protect your devices. And another one is just within the office always to use approved electronic equipment. So the phones, the laptops, the USB sticks should always just be approved devices by the organisation and not perhaps the employee's own devices that could be subject to data breaches. When it comes to electronic delivery, check and be careful about who you're contacting electronically. Check the email address. It's really important to do that. We're too quick on our email systems to put in the first few letters of a name and then assume that that's the individual that we're looking for. Be careful about that because that is a breach. If you're sending the information of a subject or of an individual off to a third party by accident, it's still a breach. Look to always password and encrypt your documents. And it's a really good idea to put delivered and read receipts on documentation as well to ensure that they're sent. Obviously, if you are passwording and encrypting documents, don't send the password in the same email. Send it in a separate email or a separate letter if it's going out that way. In terms of hard copy deliveries, it's really important to think about recorded special next day delivery, hand deliveries, if you're going to track the correspondence. If you're sending discs out in the post, make sure that they're password protected. And again, that password is going out under separate correspondence. And really simple things that the ICO have said about using robust envelopes and wrapping, using post bags. What you don't want, and what does happen quite a bit, is that things that go out in the post can end up with the envelopes ripped where they're not robust and the documentation left open for a breach to happen. Other small things in terms of the communications are that perhaps if you're sending emails where there's particular sensitive data there, that you remove the individual's names and instead use their initials. Make sure that whenever you're sending letters that the only information available might be the addressee and the address within the window envelope. Don't have a situation where there's further information that can slip up the letter and be in view of the window envelope. That's another one that I've come across. The other important point is speak to your data subjects. Whenever you're talking to them, you're identifying that it's them that you're in fact talking to. But it's also a good opportunity to check in with them in terms of making sure that the document or the information that you're holding about them in respect of any documentation is up to date, and that there is. We talked earlier on about the right for information to be correct. So it's a good opportunity that if you're speaking to someone in a data protection format to ensure that the documentation that you're holding is correct and up to date. That brings me to the end of my presentation. I hope that you've enjoyed it and that it's been informative. Thank you.